Hello friends, please like, subscribe, share and comment. It will motivate us to carry on this project for the welfare of students preparing to get government job through shorthand. Thank you for watching. Ready, start. The proviso to section 15(3) raises pecuniary jurisdiction of a court of small causes in respect of suits by the lessor for eviction of a lessee from a building after determination of his lease and for recovery of rent, oblique damage, etc. from him in respect of period of occupation during the continuance of lease or for compensation for use and occupation thereof after determination of lease to the extent of rupees 5,000. The language of provisions of statute as noticed above makes it clear that the legislature has labored to specify the cases which shall not be cognizable by courts of small causes when there is already a court having jurisdiction to try such suits, but in view of the scheme of SSC Act 1887 and sections 15 and 16 of Code of Civil Procedure, it is clear that the court of small causes is a court of preferential jurisdiction and not of a exclusive jurisdiction. It cannot be said that a civil court on regular side lacks inherent jurisdiction to try suits of nature specified in section 15(2) of SSC Act 1887. Section 15 of SSC Act 1887 came to be considered before a full bench in Manjurul Haq and another versus Hakim Mohsin Ali, AIR 1970, Allahabad 604. Though it was in the context of the question whether a decision given by a court of small causes in suit for arrears of rent will operate as res judicata in a suit filed later in the court of Munsif for recovery of arrears of rent for a different period for rejectment. In this context, the court considered the question whether court of small causes is a court of exclusive jurisdiction and answered it in negative. In para 21 of the judgment of Honorable S.D. Khare J and para 52 of concurrent judgment of Honorable Jagmohan Lal Sinha J, it has been said explicitly that court of small causes is not a court of exclusive jurisdiction, but it is court of preferential jurisdiction. Having said so, I proceed to consider Article 4, Schedule 2 of SSC Act 1887 as amended in UP. A suit for possession of immovable property is barred, but there is an exception again to bring a particular species of cases, namely suits filed by a lessor for eviction of a lessee from a building after determination of his lease and for recovery from him of compensation for the use and occupation of that building after such determination of lease. Return of plaints in suits involving questions of title, notwithstanding anything in the foregoing portion of this act, when the right of a plaintiff and the relief claimed by him in a court of small causes depend upon the proof or disproof of a title to immovable property or other title which such a court cannot finally determine. The court may at any stage of proceedings return the plaint to be presented to a court having jurisdiction to determine the title. When a court returns a plaint under subsection 1, it shall comply with the provisions of the second paragraph of section 57 of the Code of Civil Procedure and make such order with respect to costs as it deems just, and the court shall, for the purposes of the Indian Limitation Act 1877, be deemed to have been unable to entertain the suit by reason of a cause of a nature like to that of defect of jurisdiction. Section 23 of SSC Act 1887 has been considered at umpteen times by this court and on some occasions by the apex court also. The interpretation and mischief covered by Section 23 has been explained and clarified time and again. In my view, it is no more res integra. Stop.